You were served with divorce papers, but now what? Welcome to the Stephanie Young Law Podcast, hosted by me, Stephanie Young. I'm a family law litigation attorney in Covington, Georgia, with a passion for being my client's biggest legal ally. I have prospective clients that come to me distraught, letting me know that they were served with divorce papers. They say, Stephanie, how am I going to possibly protect my peace? I am so stressed out. So many what ifs. And honestly, what I've realized in handling this over the years is that having an awareness of the process of what that divorce initial service looks like to what's the next steps can really help with your anxiety and your fear. So today, on today's episode, we're going to talk about, of course, you were served with divorce papers. Now what? So let's talk about the steps. Service. So if you are the one being served, obviously, you are going to be the respondent or the defendant. You're on the other side of the court case, right? You're not the one that filed. And that's okay. And we're going to talk about that too. It's okay in the sense of, obviously I'm not saying emotionally everything's okay, but what I'm saying is that it doesn't make the other party have a legal up by any means, or that really doesn't make a difference. It's not a race to the courthouse when you're talking about divorce or custody disputes. So let's go over what the steps of service looks like. So first, if there's a potential, and it's not as often, right, that you can acknowledge service. What does this mean? It means that your spouse, whether themselves or through their counsel, has reached out to you and said, hey, here's some divorce papers, or, and here's some papers, whether divorce or any kind of family law petition to change custody or modify child support or legitimate. Do you want to acknowledge service, which means accept service, to say, hey, I got this packet. That's all that means. Or do we need to have you served by a sheriff or a process server? That's not frequent. I would say maybe 20% of cases or maybe 15% of cases that I see involve an opportunity to be able to acknowledge service. It's a lot of benefits involved for both sides. It's a benefit involved for the petitioner, the one that's filing, is because it saves them money. They don't have to pay for the process server or the sheriff. It also cuts down on time. So, once you're served, the clock can start ticking. So there's, that's their benefit. The benefit for you, if you're the respondent, to go ahead and acknowledge service is it's basically saying, okay, I got this, and I'm not going to have to interact with law enforcement, or I'm not going to have to, it helps with anxiety in the sense of you take control over the timing. So you are taking control and saying, okay, I got this. I'm signing to say I received it. Not that you agree with it, not that you want it, even if maybe you do. But that's not what you're doing. It's just like certified mail. You're signing to say, I received this. That's it. The other aspect of the option, because that's not always an option, right? Maybe they don't reach out to you. And again, I say it's really not that frequent, because unless you guys are really getting along, or if I already know, like as counsel, if I represented the petitioner, if I already know that the respondent maybe hasn't filed yet, but they've got representation, so it's coming, to try to save my client money, I'll reach out to the respondent if I have their email address, or to their counsel to see if they want to acknowledge service. It's voluntary. You do not have to acknowledge service. But it can help in terms of on both ends with a little bit of control of the timing and saving some money. The next step of service is service by the sheriff, which that's always been the standard, where when you file those documents, the petition for divorce and anything you file with it, goes to the sheriff. There's a civil service process. They go to that department in the sheriff's office, and then someone will go to the address, typically a home address. They can also serve at work, but they prefer home, and execute service. The issues with that on both ends is there's no control over timing. So it depends on how backed up the civil service department is. So they could go in a month, they could go the next day. There's just no timing, and there's no control of that timing. And so for the petitioner, that creates this idea of like just a lot of anxiety of, looking at my phone, are they going to interact with me weird? And maybe you're still living in the same home, and that's very frequent. And I couldn't imagine how awkward, right? And to be at the home with that person, and then the sheriff comes up to serve them. And so that's not ideal. It's also not as ideal either if you've got a situation in which there's violence involved, or the fear, threat, potential of violence, because then it's, okay, if this person gets angry, if they get violent, or maybe even just emotional violence, meaning, spitting words and cussing. And if you've got kids there and you're living in the same household, that's another aspect of fear. It's not just the awkwardness, it's actual fear. And those are all things why it's important to communicate through counsel your situation, so that we can help set up where you're not put in a dangerous situation as much as we can help it. The third option is to use a process server. So this is my favorite option in terms of, unless I really know that the person's going to acknowledge service, is the process server. So what that involves, it takes the control back by the petitioner, and it allows them to say, okay, I am choosing a certified process server, and good counsel has got a lineup of them to say, can't just be anybody, to say that here's a picture. Oftentimes I'll ask for a picture from my client. I'll ask them for a good schedule of typically when you think the other party is going to be at home or at work, depending on where we're serving them. And then we're able to give the paperwork to the process server and say, hey, can you go this day and time and try? So that kind of takes back the control. It is also helpful to an extent for the respondent, because it's still not it's not a sheriff coming to your door. It's going to be somebody probably in plain clothing coming that's the process server. So if your kids are there, it's not, you can kind of say, oh, it's just someone dropping something off. So it really is ideal, and that is my number one choice for my clients. So we've got that down, but I really want to talk to you about the emotional aspect of what that looks like. So once you get the paperwork, okay, take a deep breath. My first instinct's not going to say, oh, quickly call an attorney. And I know, right, that's surprising probably coming from an attorney, but honestly, because your emotional well-being is a big priority to me, I'm going to tell you to take a deep breath, okay? Accept that service packet. So whether that is through an acknowledgement, or if it's from the sheriff, if it's from the process server, get that paperwork, sign, say you received it. Don't give them trouble. They're just doing their job. Put the paperwork somewhere safe. Maybe don't even read it yet, okay? You read the title, you know what it is. Put it away for a few hours, maybe a day, maybe 2 days. Don't go too long, right? I'm not telling you, forget about it. Definitely don't do that. Put it somewhere safe. Maybe get your best friend, maybe get your mom, maybe even if it's on the phone, maybe get your pastor, maybe get somebody that you feel like can really give you a clear mindset, not necessarily legal advice, just emotional advice, a comforting person, support person to sit down and maybe go through it, okay? I say maybe go through it because I've also had, it just depends on where your mindset is. I've also had clients that say, I got this, I haven't looked at it, I know what it is, but I don't want to read what it says in terms of the facts, and that's okay too. There's no judgment, not in my office. The next step I'm going to tell you is contact counsel, and that is very important. It's not the first step because your well-being is number one, but the next step for the longevity of your well-being is going to be contact counsel. I want to talk to you about what does that look like, okay? So if you call up my firm, we're going to get some basic information from you. Not too many details. We're going to say, okay, what's your spouse's name? And the reason we're doing that is to make sure that we, haven't already consulted with them, because that would what we call in the legal field a conflict of interest. And that's very important for the lawyer to screen, right? So we're kind of doing that on the back end. We're screening and making sure in our database, we don't know that name, we haven't represented them in something that would look like or create an actual conflict. And the next thing that we're going to ask you is what county. So that could be what county, and maybe you and your spouse have been separated for a little while and you live in different counties. So we're going to ask you some questions, so that we can figure out the venue about where we're going to file that divorce to make sure that it's within the counties that we service. So of course, if you're interested specifically in me, obviously I know I talk about that you're here in my Covington office and we chat weekly, but I wanted to kind of tell you that doesn't mean that I'm constricted to Covington, right? So Covington is in Newton County, Georgia, which is also part of the Alcovy circuit. So what that means, it means that Walton County and Newton County have the same judges. So that means that if you know the judges in one of those counties, it's the same judges in the other county. They're connected. There's a couple circuits and counties that kind of match up like that in Georgia. So I service Alcovy, which is Walton and Newton County. I also service Rockdale County. I also service Henry County. And we're going to say the Ocmulgee circuit. And that's a big word for there's 8 counties in that circuit. What that looks like is some of those surrounding smaller counties like Morgan County, Putnam County, Jones County, Jasper County, Baldwin, some of those other counties that I also go to. So all that to say that I've talked about this before on the podcast and will continue to do so, and kind of reiterate that it's important when you're selecting counsel that you are looking for somebody that can tell you specific advice that is tailored to the judges in the court in which you are going to be filing, or in which a case has been filed that you are going to be presenting in that courtroom. And so the next step is to set up a consultation. So once you call my office, we go through those steps, make sure there's no conflict. We get all your information so that I can go ahead and get an idea about what debts are involved. Is there businesses involved? Is there how many children are involved? What the assets look like? Just bullet points so that I can kind of get my notes organized, because the next step is going to be that consultation. I always say that I prefer to do consultations in person. I think that there is value in having a really close interaction with somebody, getting to see their face, to really say, is this, because in a sense, I recognize this, the client, and you should be, is interviewing to see whether that attorney is going to be a good fit for them. And that's a lot of different factors go into that, in terms of it's not just the knowledge, making sure that they know the judges in that area, but it's also hearing if their plan kind of lines up for you as a plan that you want to get behind. You feel heard, because I go on about that a lot because it's important to me. And I know it's important to my clients from experience, that you feel heard and that you feel like the shoulder that you're throwing your weight and your stress on is a shoulder that can take it, right? There's a lot of value in having that confidence to protect your peace. The other aspect is being able to share some documents ahead of time. So if you've gotten served already, going ahead and saying, I'm going to say, hey, my staff will say, send a picture or scan it. If you don't have a scanner, it's fine. Just take a picture. Send us that documents ahead of time so that me as the attorney can look through, make some notes so I kind of know, okay, this is what they're alleging. Not always accurate. And I can go from there so that way when we do sit down for that consultation, that we can really go into details at that point. The next step I want to talk to you about is the process of a consultation. So now that we've got it set up, you come, and also, Zoom is a fantastic technology. As you can see, you're in my office right now through a lens, but you can still very much connect that way. And I've represented countless people that live out of state, just for different reasons as to why the venue is appropriate here in Georgia. The counties here, they've been out of state, and that's also been great to be able to utilize Zoom. I've also had clients that don't really care as much. It's less frequent to say, let's do a phone call, but I do that too. And the next step is, okay, you're on that phone, you're behind that screen on the Zoom, or my preference, you're here in my office in Covington on Elm Street, and we're going to talk in person and interact. What does that look like? You come in, maybe you're really nervous. I'm going to assume you are, right? And I'd rather do that, because my goal is for you to enter, you automatically from stepping foot into my office, know that several things, that my focus is on you, because that's what you need. You're paying for that, but you also deserve that. You're going through a hard time. The other aspect is privacy, that you know that what you're going to be talking to me about is not going to be disclosed anywhere else. What we build in that meeting, at that point in that meeting, is an attorney-client relationship. And that's very important to me. And I always disclose in my initial meetings with my clients or potential clients is that what we talk about in here is covered by attorney-client privilege. What does that mean? It means that you can tell me anything, except there's always an exception, right? That you're going to harm somebody, that I think that you're going to go kill somebody. And I really believe it. That's the kind of the one extreme exception, which I thankfully haven't had come to me yet. And I don't plan for that, hopefully. But besides that, you can tell me you did kill somebody. stays with me. That's confidential. It's so everything else. And that means a lot to me. And a lot of clients are like, or potential clients say, well, of course, I know that. Good, awesome. But just in case there was a doubt on that, it's something I always go through because it is so important that you feel not just heard, but that's a private conversation that is only heard with counsel. So that you can open up to me, tell me, because again, when we're talking about specifically divorce in Georgia, it is an equitable division state. And that does not mean equal. If you want to hear a whole nother episode on that content, let me know. Comment down below if that's something you're interested in, specifically here in Georgia. What does equitable versus equal, what does that mean? What is that standard in Georgia? And I would love to do an episode to break that down for you. We go over everything in terms of just an overview. We're not going to sit there and say, yeah, we're arguing for this. You don't have to have a plan. You don't have to say, okay, he can take this and he can take that, or she can do this. I'll take responsibility for that. That's not at all what we're looking for. So I have clients that are like, oh no, I don't know how much our mortgage is. I don't even know what debts we have. And you know what I say? It's okay. That's what I'm here for. We've got a discovery process. Let's talk about a plan. Because you don't know those things, it would probably alter our plan in terms of moving forward. We're going to need to jump on to do discovery and send discovery requests. And again, that's discovery. You might not know what that means. Exchanging documents, right? And if you want to hear another episode about that, I would love to dive deep into that. That's a huge part of family law disputes is custody exchange. So if you want to hear an episode on that, just comment down below. So we've met, right? And if you've been served divorce papers, that's what this episode is about. It means that the case is already existing. So that means that whether you know it or not, I'm telling you here that the time is ticking in terms of to file an answer and a counterclaim. You've got 30 days at that point to go ahead and file that answer. Obviously, that can be extended typically, with 45 days or more if you need it. But for my sake, what I always calendar is 30 days. So there's no question that we're making sure that that gets calendared to preserve your rights. There is no default judgment in Georgia on family law, on divorce cases. What does that mean? It means that if you don't file an answer, the judge isn't just going to automatically rule in the petitioner, the person that filed's favor. That's not how these things work in Georgia specifically on divorce cases. But it is still important that it's not ignored because there could be hearings going on that, there's going to be significant things that are argued for and it wouldn't go in your favor. So you want to make sure that you're filing an answer to go ahead and say, okay, this is whether or not I say I admit to what's being said, I deny, or I admit in part and deny in part. The other part is a counterclaim. This is when you're getting your chance to say, okay, you've said why you want a divorce. Let me say why I do. They don't have to match. Those reasons a lot of times don't match. And that's okay, but it's preserving that and laying out your claim. This is not the time to present evidence. What do I mean by that? An answer and a counterclaim is just laying out, okay, this is what I think about the petition that was served on me. I admit or deny, or admit in part, deny in part. And my counterclaim is, okay, this is what we have. Maybe we have real property. We don't even, have to go necessarily into all the specifics. Yes, we have children. This is their names and their ages. Yes, we need to discuss custody. And, you might put on there that, whether or not you want primary or sole, or you just want visitation. We can but we don't have to say, this is the schedule I want. These are the days I want to see my child. Not the time for that. That's evidence and that you would be arguing, and it's not the time to do that. It's also not the time to say how much you want in child support or how much you want to pay in child support. Not the time. No, we don't have to do that yet. You can say, I want child support, but it's not the time because we haven't done the discovery. Okay. So we don't know necessarily all the answers. And that's why I tell clients, you don't have to know all the answers right away. It's a process. The next thing that I want you to really know is this important word, 2 words, status quo. Status quo. What does that mean? It means that are you maintaining what everything looked like in terms of finances, seeing the kids, acting the same that you were before this divorce was filed? It is so important to our judges specifically in those areas that I told you I practice to maintain the status quo because it's the law. It is the law to not make those significant changes. Why? Well, let's think of it this way. And it's beneficial all the way around. As an attorney, I 100% support the idea that we maintain the status quo until the court says otherwise through an order, whether it's agreed upon order or we litigate. It's in an order that you can change the status quo. So what does that mean? It means that if you always paid the mortgage bill, you got to keep paying the mortgage bill. I don't care if you said, you know what, peace out. I'm going to go live in, I'm going to rent an apartment or stay with family. Okay, you can do that. But you've got to keep in mind that if you are the one paying the mortgage, you've got to keep paying that mortgage. Fit it into your budget. And if you can't, then maybe you have to stay until we go to court and get it changed. Okay? So that also means that we're not taking the children and we're not, running out of state to hide the children or take them out of the jurisdiction of the court. That's very important, because what that looks like is, and I've seen it happen, that that's going to look really badly on you or on that party if the other party is the one doing it when it comes to talking about custody and visitation. And we can do, again, there's a lot more content there that we can talk about in future episodes if you'd like, about what that looks like in terms of leaving the jurisdiction, with your children leaving the jurisdiction, and what to do if that happens to you. As far as the status quo, though, it's very important that, before you're making those quick, rash decisions, you understand that you've got to still maintain. And that's important, for example, my stay-at-home parents, because maybe you never had an income and now you're served divorce papers and your spouse is trying to get up and leave and you don't know how the house is about to go in foreclosure, because how are you going to all of a sudden just get a job in the snap of a hat? You're not. Is that something that I'm going to come in and say, let's talk about it, your specific circumstance, and let's see about employment and trying to give you some life advice on to build up and empower you, because that is what I'm here for as a goal of mine. Yes, but that's not going to happen overnight. That's not going to happen in a week. So that's why that status quo protects you. Now, what do I do if the other party is not following the status quo? Okay, because it happens. It does happen. If you come into my office and you're not following the status quo, I'm going to tell you need to, because it's not because, I'm fighting for the other side. No, I'm fighting for you in that sense, because it's A, it's the law, and B, what is the judge going to think when you're already in content, which means you've gone against what the court desires and what the court has ordered. Because it's Georgia law to maintain the status quo. In some counties, there are what we call standing orders, which is saying before you file this case, as soon as you file this case, I'm telling you, and Henry County has got this specific order, as soon as you file this case, I'm letting you know, kids don't leave the jurisdiction, whether that's a question to you or not, they're not. I'm telling you in a written order, and you've got to maintain the status quo. But if that happens, because obviously an order is an order, which means people are still going to do sometimes, unfortunately, what they want to do, we can do emergency hearing. There are very, very specific things, not, okay, he hasn't paid the bill today, but it's still not due for a month, okay, or 3 weeks. That's not emergency hearing, okay? So it's definitely going to take, I can't list and say these are all the reasons of what would actually classify as a legal emergency, but I will tell you this, they're very refined and few, because you don't want to throw around the word emergency when it's not really an emergency, because that is going to upset the court. Because when the court sees an emergency, and if I put an emergency on my petitions or on my motions, I really want to maintain my reputation to say, okay, if Stephanie Young, we see her, she's in our courtroom a lot. If we see she's filed this as an emergency, I want the court, I want to maintain that respect with the court to say, okay, it really probably is, and let's hurry and put it on a court calendar. But if there's any doubt, again, representation, your counsel, and at the consultation, can walk through whether or not they think that that's an emergency aspect or not. Just because it's an emergency to you, and we respect that, I respect that, does not mean that that's a legal emergency. And only representation, local representation in your jurisdiction will be able to tell you that. The next thing that's more common is that we're going to say, do we need a temporary hearing? And oftentimes, I would say 90 to 95% of the time you do. If you've got minor children involved, and if you need a temporary hearing. And the reason is because the status quo is fine, except what's the status quo when you've lived in the same house with the kids? What does visitation look like? there is really no status quo except, yes, they see the other party. So we really need to establish what that looks like. And maybe, for example, let's just say that it's really uncomfortable at the house and you really want, but if you leave, you're concerned, well, when am I going to get to see my kids? Because there's no order on that. That's another thing that's huge that we very typically address at temporary hearings, and having representation at that stage, because those can be noticed as soon as service is perfected. So as soon as the respondent is served, the other side, the petitioner, that notices that we can go ahead and get a court date. So, you could get served and have a court date in 3 weeks, and it's not even really an emergency. It's just a temporary hearing, which is, again, why it's important. I told you, take care of your emotions right earlier in this episode. But the next step, and I don't mean weeks later, I'm talking maybe the next day, the next 2 days, call counsel so that you have that set up to make sure that you've got representation, especially at that temporary hearing. The next step is going to be a final hearing. And there are a limited number of cases in which there are no other hearings except a final hearing. In terms of what those cases look like, maybe you've been separated for a couple years, right? And so it's just time to get the divorce finalized. It's time to maybe list the house or argue over who gets what equity out of it. But there's no those right now issues that have arisen. Then we would just maybe exchange discovery at that point and then prepare so we've got all the evidence we need for a final hearing. Or maybe we mediate ahead of time to see if maybe we even need a final hearing. Maybe we could just mediate and you never have to step foot in the courtroom. So all of that, I knew that was a lot of content, but my goal from this episode was really to I think that an informed person is going to be a less anxious person. So knowing what does that look like moving forward, and I hope that has been informative to you. If you've been served with divorce papers, take a deep breath, then call counsel. It's important to have an experienced legal ally on your side from the start, because peace is priceless and attainable. We've got this. It would really mean a lot to me, my family, my kids, if you would like, subscribe, and share with your friends, family members, coworkers, anyone that you think that this content can be relevant. Hey guys, I just wanted to jump on and give a disclosure that watching my videos does not create an attorney-client relationship. Also, the information that's contained within the videos is for educational purposes only. Thank you so much for watching.